not completely distinct, because in the ports campaign, the model is also to try to promote unionization among the ports. But so that might not work as a framework of trying to distinguish, organizing sort of outside formal unionism with organizing then. On the ROC stuff, I mean, I completely agree with you, and I think it's a really innovative model. I don't want to suggest that litigation isn't ever affirmatively used. That's not what I want to say. I just think it's used differently. Even within the ROC model, it's used very differently. It's not as if ROC tries to litigate a particular legal theory and to get a definitive ruling on the merits from a court. They're using it in connection with organizing to try to put pressure on a chain of restaurants that are interconnected and to get them to change policies and to settle. They want to settle. And in their settlement agreements, then they do really innovative things, like they create provisions that are effectively sort of collective bargaining agreement-ish in their sense that they're proactive. But that's very, I mean, so yes, it's litigation as a sort of sword, but it also looks different in the sense that it's not trying to get, it's not a court-centered model in the sense that their end game is to get a legal ruling that then is supposed to change behavior. It's to change behavior through the combination of sort of law and organizing and the private agreement that they strike with the actual employer. I mean, yeah, I mean, of course, for Jennifer Gordon stuff with the workplace project. I mean, one of the campaigns that I study is in the garment industry, and again, there one of the major accomplishments was getting state legislation that created guarantor status for manufacturers of garments as opposed to the contractors. So I guess sort of my local shift is sort of away from the federal to some degree and sort of toward state and local. I think it's primarily played out around local initiatives, but there's been some important state law stuff that you identify. Other questions, comments?
Okay, if there's no further comments, let's.
Go
for it, Nancy. Who are you?
Good. So I guess what I'm trying to also understand is see how enforcement is litigation a way of enforcement for employers per se? Like what other ways of, I guess I'm kind of tired of hearing enforcement is a way of changing, labor laws, organizing. Like I feel like the push is always enforcement. And I don't know if I see this through here, or is this another way of like how employers can change themselves versus just being pushed to enforce what policies and laws already exist. Does that make sense?
Yeah, I mean, I think the ROC example is a really good one and I think what the Workplace Project did in Long Island also is an example of taking. So I had the sort of models of sort of legal strategies, and one was about enforcing employment law. And I think one thing that groups have tried to do is to innovate around different models for enforcement, because when you have an industry like the garment industry in Los Angeles, where 2/3 of the contractors are not adhering to minimum wage and overtime laws, you have a systematic failure of enforcement. And the question is, how do you try to ramp? I mean, there you're just trying to ramp up enforcement in order to hit the bare minimum. You're not trying to improve conditions in the sense of creating sort of a legal bar that's higher than the minimum. You're just trying to hit the minimum. And so the question is how you sort of think about marshalling enforcement strategies in order to get there. And I think so the ROC example is a really good one of that, because you have the same sort of paradigm in the restaurant industry, and there you're trying to leverage both the power of litigation and the publicity really that litigation affords, because a lot of the strategy is because you could win a court judgment that an employer hasn't paid minimum wage and overtime laws, and you could find it impossible to collect, because it actually ends up being really hard to collect judgments that you get through courts on these kinds of issues. And so what the ROC model does that I think is quite innovative is that it uses the lawsuit to actually generate publicity that then is leveraged to try to really embarrass and promote consumer boycotts of well-known restaurants. These are the sort of Smith and Walensky chain restaurants that have a lot of different partners, and so it can be utilized in that particular way. And then they go and they protest in front of the restaurants in order to dissuade people from coming. So there's a different mechanism of trying to enforce. I think that the problem with that, and this happened in the garment industry, is that when you rely on case-by-case enforcement brought by individual workers, it's hard to sort of be broad enough and have enough resources to actually capture all the bad actors. And unless you're able to make really powerful statements with litigation that then is communicated to other actors within the industry that dissuades them from violating the same sorts of laws, you're sort of constantly following around people that are, the employers that are violating the wage and hour laws and trying to get them to actually do the right thing and sort of meet the baseline minimum standards. And that just is an extremely resource-intensive project, which I think is hard to accomplish without a lot of resources. So one of the things that I think these strategies try to do is to move away from the individual enforcement paradigm to some degree and to create alternative structures that don't require that sort of resource investment in order to make it effective.
Can I ask a question?
Yeah, the comfort zone.
I'm Saul from the law school. So it's a really exciting project, thank you. So I wanted to ask a question about the larger political context and the time period that you're looking at, and I wonder if you're even asking this of the groups of folks you're talking to, or if it's come up. But so the story around LA and around progressive politics and the role of unions in the legislative context, I think one could walk away from what you just told us saying people pretty much are strategizing around getting policymakers that are going to be favorable to these kinds of initiatives into office, and the LA County Fed has had a major role at all these levels in electing pro-labor mayors and officials. And so I wonder if it's your sense that at least in this time period, that there's more nuance, like are people actually satisfied? Is there some tension around expectations regarding, let's say the Villaraigosa administration here in LA or other sort of union-backed or progressively backed candidates? And has the landscape, do people feel like the landscape has been fundamentally transformed on the one hand, or that it's pretty much still developers and the same folks at City Hall that they're constantly having to come up against?
That's a great question. I don't have a definitive answer on the sort of disillusionment point. I'm sure that there is some. I think it's sort of mixed in terms of how people think about the impact of the success. I think sort of if we focus on the sort of community benefits domain, which is one that I've studied sort of most closely recently, I think people think on the one hand, it's not just business as usual anymore. If you're a developer in the city of Los Angeles and you want to do a big project and you're going to get public subsidies, you're going to have to make some effort to try to enter into a good faith agreement with community groups that are going to provide something, give something back. And so the old paradigm of developers and city officials talking behind closed doors, rolling out plans after they've already been effectively agreed to, and then having sort of public meetings where people come and rubber stamp,